Welcome back to another J. Harris Academy Police Training Roll Call. I'm Joey Sperlazza, instructor. Today we're going to be discussing a Miranda case, but before I get into that, we're going to talk about something that's even more important, the United States Constitution. What does the Sixth Amendment say, and how does that apply to our Miranda cases? Under the Sixth Amendment, in all criminal prosecutions, the accused shall enjoy the right to be informed of the nature and cause of the accusation. If you have somebody that is in custody and you already have a warrant that's approved against that individual, they must be informed of all of their charges prior to any questioning. If you fail to advise them of those charges prior to questioning, that entire statement could be suppressed. In this case, we're also going to discuss more about the Miranda rights and making sure that the individual knowingly, intelligently, and voluntarily waive their rights. So let's get into the details of the State of New Jersey versus Jorge Ramos-Compres. This is an appellate division unpublished opinion from New Jersey decided on January 22nd, 2025. Here, the defendant is going to appeal the denial of his motion to suppress a statement claiming a violation of Miranda and failure of police to advise him of his pending charges. The defendant was charged in connection with a shooting near a Home Depot in Passaic on January 8th, 2013, resulting in the death of Alex Siri. 2 days after the shooting, officers from the Passaic Police Department arrested the defendant in Sussex County around 4 o'clock in the morning. The officers drove the defendant to police headquarters in Passaic to be interrogated. Interrogating officers first met with the defendant around 10:30 a.m. on the day of his arrest. Prior to speaking with the defendant, Detective Rodriguez of the Passaic Police Department read the defendant his Miranda rights in Spanish. After reviewing the Miranda waiver form, defendant initialed inside the form, agreeing to waive his rights and speak to the police. The police videotaped the interrogations, and during his first recorded statement, the defendant denied being present at the shooting and said he did not know what happened that night. The detective told the defendant that testing confirmed the presence of gun residue on the defendant's hand. The defendant still insisted he knew nothing about the shooting. The detective ended the first interrogation. About 2 to 3 hours after that first interrogation, the defendant approached the detective and said, "I want to speak with you again." The detective never fully re-Mirandized the defendant. He presented him the previously signed form and asked him, "Do you remember signing this? Do you remember your Miranda rights?" Okay, then we'll go forward with the interview. So what will later be addressed by the court is, did he knowingly, intelligently, and voluntarily waive his rights? Because if not, everything we're about to see in this second statement, which he gave some incriminating remarks, would have been suppressed. So during the second statement, he said, "A group of gang members shot at him. Defendant admitted to being at the scene of the shooting, but denied shooting anyone. The detective accused the defendant of lying, and the detective explained that the defendant would likely not see his family, particularly his younger sister, who considered the defendant a father figure if the defendant continued lying. The defendant eventually admitted having a gun and firing 2 shots toward the group of people walking near the Home Depot. However, the defendant maintained his shots did not strike anyone. According to the defendant, he discarded the gun in a black trash bag and left the bag in a park near a local church, but it was subsequently moved from that location. The detective said he would try to request a bail reduction if the defendant retrieved the gun. Defendant then asked detective if the gun has a number, and if the defendant fired the gun, could the police check the number associated with the gun to determine that the defendant did not kill Siri. Detective responded, "Of course," and based on the detective's response, the defendant agreed to retrieve the gun, which he said was in the basement of his home. Accompanied by the detective and other Passaic police personnel, the defendant went to his home and retrieved the gun and ammunition from his basement. The gun was a starter pistol, which was inoperable and unconnected to the shooting. The ammunition retrieved from the defendant's basement was the same caliber as bullets fired during the shooting, but the ammunition was not linked to Siri's death. After the defendant retrieved the gun and ammunition, he returned to the police station. Detective then interrogated the defendant a third time. In this statement, the defendant described turning over the gun and ammunition to the detective. The defendant further stated that no one forced him to fire his gun on January 8th, but he did so to protect a friend from being shot. The defendant claimed he intended to shoot at someone named BB because BB shot at defendant while he held his little sister and threatened to hurt him and his family. Before trial, defendant moved to suppress his statements to the police. The defendant argued that the police failed to advise him of the crimes he supposedly committed, did not honor an invocation of his right to remain silent, and neglected to reissue the Miranda warnings before his second recorded statement. The motion judge denied the suppression motion. The trial judge found, prior to the defendant's first recorded statement, he was read his Miranda rights in Spanish and acknowledged he understood those rights. The defendant initialed and signed the appropriate places on the Miranda waiver form. The defendant was clearly engaged with the detective, leaning over the table in a very cooperative demeanor. The defendant was clearly aware that he was suspect of the crime and that it involved a shooting. The defendant further argued that the detective employed coercive tactics in the first recorded statement to compel his confession. He asserted that the detective emphasized his little sister and mother needed him and asked who would take care of his family if the defendant went to prison. The defendant also claimed statements by detectives such as, "No one's going to hurt you," "Don't let me leave without letting me help you," "Do things right," "Prove to me that you are a responsible man," "This is your opportunity to fix your life," "You're going to jail for a very long time," "You have an ugly heart," "You're the devil," and "You're going to be behind bars with animals," pressured him to confess to a shooting he did not commit. The motion judge found these statements were a softening up technique employed by the detective to encourage the defendant to talk about his life aspirations and his family. Detective used this technique before asking defendant any substantive questions related to the shooting. Detective often made statements rather than asking questions during the defendant's first statement. The first statement contained personal anecdotes from the detective's own life, who discussed with the defendant why a person should be responsible in life. Prior to any inculpatory statements by defendant, detective told defendant he was charged with trying to kill a person. When defendant continued denying involvement in the shooting, the detective responded, "You killed a guy. You killed him. You're on video. You have gunpowder on your hand. We have everything." The judge noted that the defendant and detective were dancing around the topic of the shooting during the interrogation. The defendant was told by the detective that police found gunpowder residue on the defendant's hand, and people gave statements implicating the defendant in the shooting. It was not an alien notion to the defendant that shooting at somebody was involved in the charges contemplated. While the defendant was under arrest and suspect in the shooting at the time of the interrogation, there was no formal complaint filed. The suppression motion judge also found no evidence that the defendant invoked his right to remain silent at any point in the interrogation. The detective terminated the first recorded statement because the defendant failed to provide any inculpatory information. The defendant never gave any hint of his saying, "I don't want to talk to you." The defendant's second recorded statement commenced a few hours after the completion of the first statement. The defendant initiated that conversation. There was no evidence that police persuaded the defendant to continue talking. The defendant's request to resume speaking with the detective was attributable to defendant's guilty conscience and not any impermissible tactic employed by police. The defendant confirmed he wished to continue speaking with the detective prior to the start of the second statement. Before the second statement, the detective pointed to the Miranda waiver form signed and initialed by the defendant a few hours earlier. The detective held up the signed Miranda waiver defendant had executed a few hours earlier and made reference to it. There was no intervening event or prolonged time frame between the defendant's first and second recorded statements for there to be a need of a full second Mirandization. The defendant argues that he was sleep deprived during his three-part interrogation. He further asserts his youth, 19 years old at the time of the arrest, rendered invalid any waiver of his rights. The defendant also contends police failed to advise him of the offenses he allegedly committed before questioning him. Finally, the defendant argues that the detective undermined the Miranda warnings by implying that the detective would try to reduce bail or otherwise help the defendant if he confessed to the shooting. The defendant was convicted at trial. He makes an appeal and he makes a motion to suppress the statement. The appellate court ruled that the state proved beyond a reasonable doubt that he knowingly, intelligently, and voluntarily waived his rights. At the appellate division, the judges ruled, for a defendant's waiver of Miranda rights to be valid, the state must prove beyond a reasonable doubt that the waiver was provided knowingly, voluntarily, and intelligently. Whether the state met its burden is determined by the totality of the circumstances surrounding the custodial interrogation based on the fact-based assessments of the trial court. The totality of the circumstances require considerations of factors such as the defendant's age, education and intelligence, advice as to constitutional rights, length of detention, whether the questioning was repeated and prolonged in nature, and whether physical punishment or mental exhaustion was involved. Other relevant factors in the totality of the circumstances analysis include whether the police made any representations that directly conflict with the Miranda warnings, promises of leniency by offering counseling as a substitute for jail, and statements that minimize the seriousness of the crimes under investigation. When neither a complaint nor an arrest warrant have been issued, as in this case, the police are not required to inform the arrestee of the potential charges prior to conducting an interrogation. Despite being 19 years old, the defendant was gainfully employed and living on his own at the time of his arrest. Additionally, in the recorded statement, the defendant engaged with the detective in a meaningful manner, belying any suggestion that he did not understand the detective's questions. Based on the interrogation, the defendant knew that there was a shooting. Further, the detective informed the defendant that police found gunpowder residue on the defendant's hand. The defendant also contends the detective impermissibly undermined the Miranda warnings. According to the defendant, the detective promised help by stating he would try to reduce the defendant's bail. The detective made no promises to the defendant. Rather, the detective said that he would try to request a bail reduction, but also told the defendant a reduction might not be possible. During the defendant's first recorded statement, the detective used a softening up technique to appeal to the defendant's sense of decency and conscience. Such interrogation tactics are permissible, and nothing in the detective statements indicated that the defendant's will was overborne. The defendant argues his constitutional rights were violated because the police failed to reissue Miranda warnings before the defendant's second recorded statement. However, the defendant was reminded he signed the Miranda waiver form a few hours earlier before speaking to the detective a second time. On these facts, there was no need to repeat the Miranda warnings to the defendant prior to the second recorded statement, and the evidence seized as a result of the defendant's second recorded statement were proper. Appeal is denied. On a very serious note, if you are in this situation, especially if a couple of hours have gone by, best practice is always to re-administer those Miranda warnings. That way, these arguments can't even be brought up in court. And in these unpublished opinions that we study, there are different panels of judges. This panel thought that they did not need to re-administer the warnings. A different panel may have said, you know what, too much time had gone by, we should have re-administered and they could have suppressed it. Rather than even giving the defense a chance to go down that road, re-administer the Miranda warnings. On an additional note, if you haven't studied this in the past under that Sixth Amendment clause, we need to make sure that if a complaint is filed, we are administering those Miranda warnings, and we are clearly telling the person what they are being charged with. Tell them that agrees. I would even show them a copy of the warrant to make sure that they are very clear as to what the charges are against them prior to that interview being conducted. If you haven't actually filed a formal complaint, it's not required. But like they said in this case, he was aware of why he was being interrogated. There was no type of deception by the detectives. They advised him that there was gunpowder residue on his hand, but that should be part of your interview. And we constantly see in these cases appealing to that conscience and sense of human decency with people. That is going to be a permissible technique, but you want to make sure that you're not being too overbearing. When we're seen as being overbearing, it could lead to some sort of a suppression. So always use caution. Keep reading these cases. Keep watching these videos because it'll help you understand what you can and cannot do. Because the last thing that you want to do is violate somebody's rights and then get something suppressed. It opens you up to an entire world of problems. So I hope you guys enjoyed this video. Took a lot away from it. I'm looking forward to more roll calls with you guys. Stay safe.
This podcast is brought to you by the J. Harris Academy of Police Training. J. Harris Academy of Police Training is based in New Jersey and provides law enforcement training services nationwide for promotional examinations, use of force, supervisory development, and other key areas within law enforcement. This podcast is utilized to discuss key topics occurring within the profession. The opinions and information provided is for entertainment purposes only. In an effort to provide this, we often purposely discuss opposite views and opinions to spark conversation and develop discussion points. The contents of the show and show notes are all copyrighted. All blog posts, podcasts, and show notes that are distributed to the public for free can be redistributed via hard copy or electronic copy for free only if the J. Harris Academy of Police Training is included as the acknowledged author within the actual media that is redistributed. This entire disclaimer also applies to any guests or contributors to the podcast or blog. Under no circumstances shall the J. Harris Academy of Police Training, any guests, contributors to the podcast or blog, or any employees, associates, or affiliates of the company be responsible for damages arising from the use of the information provided.